Legislature's back in session. Let's stay on the resolutions for right now. Madam Vice Speaker, resolution number 39 is yours. You're recognized.
Thank you very much, Mr. Speaker. I rise to make a motion to place resolution number 39-34 into the third reading file. I'd like to discuss the motion.
Hearing no objection.
This resolution is meant to express support for the legislation in U.S. Congress that seeks to expand compensation to residents of Guam who may have been exposed to ionizing radiation and contracted cancer and other illnesses through the Radiation Exposure Compensation Act, otherwise known as RECA. The RECA program can be a resource that provides justice and compensation for people of Guam who are suffering from cancer and other illnesses. The passage of this bill in Congress would allow those who resided on Guam between the years 1945 and 1960, or roughly 50 to 60,000 people who suffer from cancer or other listed radiation-related illnesses, to apply for compensation up to $150,000 from the remaining funds in the RECA Trust Fund. And this is a trust fund that is already funded. There's a Senate Bill S-197, and it would amend the Radiation Exposure Compensation Act of 1990 to expand the list of eligible downwind areas to include Guam for the nuclear weapons testing conducted in Marshall Islands from 1945 to 1962. After this resolution was introduced here in Guam, there is a House bill that was also introduced, H.R. 2049, also titled the Radiation Exposure Compensation Act Amendments of 2017, like the Senate Bill 197. The language of H.R. 2049 mirrors S-197, and the only difference is that in the House, they go further and they add that the veterans who did nuclear cleanup at the Inuitak Atoll they add them to the list of people eligible for compensation. And as you know, I also sponsored a resolution that we will move after this that is in support of those veterans as well. The Guam Legislature has championed this effort to include Guam as a downwind area under the RECA statute for many, many years, as far as I can remember. And I know that Speaker and many others and many who have passed have really sought for this type of justice. And so I'd like to thank them, and I'd also like to thank the Pacific Association of Radiation Survivors. It's a nonprofit group, and they have been diligent advocates for this effort also. And of course, I would like to thank Mr. Robert Celestial. He is really the reason we have this information in front of us, because this information about the radiation exposure on Guam was classified for many, many years. And when it became unclassified, Robert took it upon himself. He searched through the documents, he got the evidence, he went and they found the person who was monitoring the meter that day, and got his written testimony. And all of these efforts and they went and testified to Congress, testified to the Department of Energy, and in many places to ensure that Congress would, get the evidence that it needed to include Guam. And Congress did, and there are findings in the subcommittee that Congress authorized to study this. There are findings that the exposure did occur on Guam. And so there are many, many efforts that brought us to where we are today. I would like to introduce two floor amendments, and they've been passed out. One is just to the title, and that is to include, after S-197, the words "and H.R. 2049" to include the bill that was introduced in the House of Representatives as well, and to also include the date, so where we talk about the date of introduction for the Senate bill, January 2024, that we also add, and the words "and April 6, 2017, to reflect the date that H.R. 2049 was introduced in the House of
Amendment offered by Vice Speaker. Any objections? Any senator wish to be heard? There being none.
Thank you very much, Mr. Speaker. And my second amendment is just because of the other bill that's been introduced in Congress. I'm amending on line 11 on page 4. So page 4, line 11. And this also has been passed out. I'm adding the words after, I'm changing the word bill to bills, and I'm adding after the Senate Bill 197 and H.R. 2049, cited as the Radiation Exposure Compensation Act amendments of 2017. And I'm deleting the sponsors of S-197 by this amendment. So it should read, whereas the bills S-197 and H.R. 2049, cited as the Radiation Exposure Compensation Act amendments of 2017, were introduced in the Senate and the House of Representatives by Republicans and Democrats. And then the rest of the paragraph will continue.
On this second amendment of the Vice Speaker, any objection? Anyone wish to be heard? Madam Vice Speaker.
I have no further amendments, Mr. Speaker, and I thank you very much for my colleagues for the support of this resolution. Thank you very much.
On the main motion, the resolution introduced by the Vice Speaker, any senator wish to be heard? Senator Frank Uggan.
Thank you very much, Mr. Speaker. Good afternoon to you and our fellow colleagues. Mr. Speaker, I'll make this very short and quite brief. I just want to stand and recognize an individual that the sponsor of the resolution certainly highlighted is Mr. Celestial, who's the president, if not chairman, of the Pacific Association of Radiation Survivors. And you know, Mr. Speaker, this is an issue that he has been advocating for over, if I can recall correctly, in excess of 10 years. He has not only used his personal funds to visit Washington, D.C., to do some research. He sought out some additional professional advice in terms of how to go about this entire process. And the most recent presentation that he gave, he shared that in fact the window of opportunity for any of the downwinders who may have been affected by this situation is closing. That being the case, I certainly stand in support of this particular resolution. I thank the sponsor for introducing it on behalf of the members of the 34th Guam Legislature, but most especially on behalf of the people of Guam, and in particular on behalf of all those who may have been affected by the downwind effects of the exposure to radiation and to some of these chemicals. So, Mr. Speaker, I certainly hope that once this is passed by this body, that we will be able to collectively show force, so to speak, in terms of trying to get Guam involved in this process, recognize that some of our people may have been exposed, and appropriately work towards their, if not compensation, then at least addressing those particular issues. Thank you very much, Mr. Speaker.
Thank you, Senator Uggan. Senator Castro, you recognize.
Thank you, Mr. Speaker. Just some words of commendation again for the author for having built upon a solid foundation. I also want to acknowledge the hard work of Robert Celestial. I can remember the day he walked into the late Senator Angel Santos' office with two full suitcases of empirical data and other printed types of evidence. I also like to acknowledge the work, the foundational pieces done by former Speaker Mark Forbes, who impaneled the Special Investigative Committee of the Guam Legislature and assigned Senator Angel Santos to lead that investigation. And again, thank you to the author and the supporters, sponsors of the resolution, to Mr. Celestial, late Senator Angel Santos, and also the late Dr. Walter Chris Perez for having worked with Mr. Celestial on establishing a solid case for Guam.
Thank you very much, Senator Castor, for reminding us of the efforts of those pioneers that have pushed this through for us. Any other senator wish to be heard on the resolution? Senator Lee.
Thank you, Mr. Speaker. It gives me great pride to just mention in this esteemed hall that we are members of the oceanic family. The peoples of the Pacific have a rich culture that goes back centuries, and we've lived and died on islands scattered across thousands of miles. We made our way from island to island, atoll to atoll, in an effort to explore our world, expand our community, and enrich our diverse cultures. It would seem that the U.S. government, however, considered our ocean, our land, and our cultures somewhat expendable. And after World War II, a war that disrupted the traditional cultures across the Pacific and made significant impacts to our own island, the military conducted dozens of nuclear tests. The extent of these tests is something that history, even at the closest to these explosions, has not truly reckoned with. I was shocked to read that the Atomic Energy Commission detonated 67 nuclear devices in or around the Marshall Islands. That is a massive amount of destruction done without the consent, or in many cases, even the knowledge of the people who lived in those areas. Being downwind of nuclear testing areas, Guam also felt the effects of these tests. Following the detonations, we were exposed to nuclear test particles. We have never been fully compensated for the long-lasting damage to our health and our environment caused by these tests. I am in strong support of Resolution 39-34 to include Guam as a downwind area, which could potentially give Guam residents the opportunity to receive compensation for the damage done to our island's environment and our people. I also want to commend the work of Mr. Robert Celestial, having had the opportunity to work with him and learn a little bit more about this issue in Congresswoman Bradalio's office. I would also like to commend the efforts of all of our stakeholders, all of our advocates on this issue over the years, and I thank the Vice Speaker for her leadership, and I encourage all our colleagues to support this resolution. Thank you very much, Mr. Speaker.
Thank you very much, Senator Lee. Any other senator wish to be heard on the resolution? Senator Munoz.
Thank you, Mr. Speaker. I stand here in support of the resolution, and my sentiments are pretty much the same as all the previous speakers before, all my colleagues before me, and I really just want to acknowledge the author of the resolution and Uncle Robert Celestial for really advocating for cancer. Now, it may not cure cancer, it may not bring back some of our loved ones who have passed because of cancer, but at least it'll move us one step forward, and any step forward is a good step, especially in regards to our families and protecting them. So thank you so much, and it also gives us a peace of mind. So I rise in support of this. Thank you, Mr. Speaker.
Thank you very much, Senator Munoz. Any other senator wish to be heard? If not, Madam Vice Speaker, you recognize to close.
Thank you, Mr. Speaker, and I would just like to take this time to thank all my colleagues once again for their support, for their support for seeking justice for Guam, and to all of those who came before us, who put in much time and effort, and it sometimes looked crazy to others, I have to say. When you're the first person to say that there's such a thing that happened to Guam, it was not well received. So, but they, through very, very diligent efforts, persevered and proved it. And so I'm very proud of the people of Guam in their efforts, Mr. Celestial, of course, and very grateful to the members of all the legislatures before us and to my colleagues. So thank you, Mr. Speaker.
On the motion to place Bill 39-34 in the voting file, any objection? Hearing none. Madam Vice Speaker, you're recognized on your next resolution, 40.
Thank you, Mr. Speaker. I move to place resolution number 40-34 in the third reading file. It's
Any objection? Hearing none.
There are currently two bills, one in the House of Representatives, H.R. 632, and one in the Senate, S. 283, that would extend medical care and pay compensation benefits to the cleanup veterans of the Eniwetok Atoll and their dependents through the Radiation Exposed Veterans Compensation Act. This resolution and the bills in Congress seek justice in the form of medical care and compensation for those veterans and their dependents who suffer from cancer and other medical conditions. There are veterans on Guam who participated in the cleanup of U.S. nuclear test sites without being told of the danger they were in from exposure to radiation. In 1988, the Radiation Exposed Veterans Compensation Act listed 21 cancers as radiogenic: leukemia, multiple myeloma, lymphoma, primary liver cancer, alveolar carcinoma, cancer of the thyroid, breast, pharynx, esophagus, stomach, small intestine, pancreas, bile duct, gallbladder, salivary gland, urinary tract, bone, brain, colon, lung, and ovary. When I read this list, I can't help but think I feel like I know someone in each of these categories, unfortunately. I mean, that's our experience here on Guam. But it is estimated that 35% of those who handled the nuclear waste now suffer from some form of cancer. Robert Celestial is actually one of the people who was sent to Eniwetok to clean up as part of the Army, his service to the Army. And yeah, I've seen pictures of him standing on top of the dome that they built. First they had to clear the water out, and then they, put all the debris in from the detonations, and then they covered the dome with cement. And they were standing on top of that dome in their shorts and no shirts, celebrating that their work was done, or a hard day's work. But yeah, at the time they were not informed of what they were really being exposed to. So the people who were, the military members who were in the Marshall Islands or on ships next to the Marshall Islands during the detonations, they have been included in these acts to compensate them for their exposure to radiation. But those who went to clean up, they still have not. So the bills in the U.S. Congress mandate that these radiation-exposed veterans of Guam would be entitled to the presumption that a veteran's disease was caused by radiation if the veteran was involved in the cleanup and developed one of the presumptive diseases. So again, I ask my colleagues for their support. I thank them for their support along the way, and I urge them to pass this resolution. Thank you very much, Mr. Speaker.
Thank you very much, Vice Speaker. Senator Ogden, Senator Lee. Any other senator after Senator Lee? Senator Ogden, you're recognized.
Thank you very much, Mr. Speaker. Mr. Speaker, I once again would like to stand in support of this particular resolution. And in addition to everything that the sponsor has highlighted in terms of the exposure and the possible illnesses that may have resulted as a result of the exposure to this particular situation, the underlying purpose behind this resolution is to ensure, and this is part of the resolution on page 3, line 13 to 16, the regulations authorize the VA to provide medical care and pay compensation benefits to confirmed on-site participants and dependents of on-site participants in a test involving the atmospheric detonation of a nuclear device and indemnity compensation to certain survivors. So, Mr. Speaker, we're just asking in this case that any of our veterans who may have been exposed, that they can avail themselves of either proper medical care or appropriate compensation. So I stand in support of this amendment. I thank the good Vice Speaker for her advocacy on behalf of the veteran community as it applies to this situation, and I certainly support the resolution. Thank you very much, Mr. Speaker.
Thank you very much, Senator Ogden. Senator Lee.
Thank you, Mr. Speaker. As we noted in discussions of Resolution 39-34, the Pacific has long been a testing ground for some of the world's most destructive and harmful weapons. At Inuitak Atoll, an entire island was destroyed by a thermonuclear hydrogen bomb in 1952. What was left behind was a 164-foot deep crater and toxic radiation. Under federal law, which was passed in response to the many reported cases of cancer and illness related to radiation exposure, service members who were present at nuclear tests and who have been diagnosed with certain illnesses qualify for benefits and compensation. Cleanups at Inuitak, which were carried out in part by Guam service members, were not included in this legislation, Mr. Speaker. So once again, Guam soldiers were left behind. Despite their efforts, despite their devoted service, and despite so many making the ultimate sacrifice, Guam's veterans struggle to receive the same access to care as veterans elsewhere. I'm encouraged also that H.R. 632 and Senate Bill 283 have been named the Mark Takai Atomic Veterans Healthcare Parity Act in honor of Congressman Mark Takai, who recently passed away, I believe last year. By advocating for the inclusion of Guam service members in the Radiation Exposed Veterans Compensation Act, Resolution 40 is a step in the decades-long process to atone for the damage done to the Guam veterans who put their lives and their health at risk as they dutifully serve their country. We are asking for parity. We are merely asking to be treated the same. I rise in support of this resolution and with the hope that our leaders in Washington will listen to the voices of our people, who only seek the care and support for our veterans afforded to others who have served. So again, I stand in support of this resolution, and I thank the Vice Speaker for her leadership, and I encourage my colleagues to do the same. Situs Masi.
Thank you very much, Senator Lee. Any other senator? Senator Munya?
Thank you, Mr. Speaker. I rise again in support of Resolution 40-34. There's really not very many places that I go to where a veteran won't come up to me and explain where they were and what they did and how it's affecting their lives today, and not just them, but even their families too as well. Mr. Speaker, there are a lot of different types of cancer in the world, and maybe we can't pinpoint where it came from, but for some reason the veterans know. They know where it came from, and we're here to support them and thank them for the fight. So thank you very much to the Vice Speaker for this resolution, number 40-34. I rise in support of it.
Thank you very much, Senator Munya. Any other senator wish to be heard on the main motion? If not, Madam Vice Speaker, you're welcome to close.
Thank you, Mr. Speaker, and thank you to all my colleagues. And I just want to say that I know that, sometimes it seems like these resolutions are introduced year after year, but we've seen a lot of change here on Guam in the last few years, and I'm very hopeful, and I'm dedicated, and I feel like my colleagues are as well, that to see justice for Guam as in any way that we can support that. I know that they will all be there, and so I want to thank them and tell the veterans that we're going to do our best, and that we are not doing this as a futile attempt just to make some noise, and that we really actually hope, with all the craziness sometimes that it feels like it's going on in Washington, that we're actually going to get some change. And so thank you again to all my colleagues. Thank you, Mr. Speaker.
Thank you. On the motion to send the resolution 40-34 to the voting file, hearing no objection, Senator Frank Egan, you're recognized on resolution 62-34.
Buenas tardes, Mr. Speaker, and good afternoon. I'd like to move for the placement of resolution number 62-34 COR into the third reading for consideration by the body, Mr. Speaker.
Hearing no objection,
Thank you very much, Mr. Speaker. First of all, I want to take this opportunity to thank the leadership of the Port Authority of Guam for having briefed me and given me really an up-to-date synopsis of what's been transpiring with the Port Authority of Guam versus the YTK Guam situation. And you know, Mr. Speaker, when the situation was presented, I had the opportunity to sit into some of the discussions during the court hearings and to listen intently to the nature of how a particular judgment was rendered raises a serious concern from my perspective. And Mr. Speaker, one of the judgments that was rendered is the payment of up to approximately $15 million out of the Port Authority to the Guam YTK Corporation. And if you take a look at the resolution, it highlights for a number of years the tracking of a lot of the activities that have taken place with regards to this situation. So there's no need for me to enumerate that. But Mr. Speaker, there's a few things that I want to mention. One is on page 2, lines 8 to 15. It highlights one of the court decisions that was rendered. And then moving on to page 3, with regards to the arbitration award, it mentions the awarded amount by virtue of the arbitration. And moving on through the rest of the resolution. I wanted to highlight that, Mr. Speaker, because if you take a look at the resolution, it really provides a history of what has transpired in this case. We are looking at a situation where an arbitration panel rendered an arbitration award. Individuals, an arbitration panel, Mr. Speaker, and perhaps you would be in a much better position to be able to describe it. But an arbitration panel is a representative chosen by Party A and a representative chosen by Party B who have a dispute, and then there's a neutral third individual that is selected to sit on that arbitration panel. And their decision is to render an award by virtue of the dispute. And Mr. Speaker, I'm going into this because I look at this and I ask myself the question, other than the governor of Guam, on behalf of the government of Guam, and this body, I look at it as these are the only two entities that can literally, outside of the Government Claims Act, render an award in excess and outside of the Government Claims Act based on legislation that's passed by this body. I look at this and to me, that is one of the underlying concerns that I have with regards to the introduction of this resolution, is to even imagine that outside of this body, that any individual, neither elected by the people of Guam, can have that discretion and that authority to obligate the government of Guam and the people of Guam in excess of the Government Claims Act. So let me come back full circle, Mr. Speaker, to the resolution. This resolution asks that, in fact, our legal counsel or a legal counsel to be assigned render an amicus curiae brief to the Superior Court and the Supreme Court that would highlight two aspects. One is the authority for sovereign immunity. To me, and based on legal review, sovereign immunity, unless it's waived by this body, is an organic act authority. And no one other than members of this body can waive that particular provision. And you and I know that we have a few instances by virtue of some loans that have been taken out on behalf of the government of Guam. The second aspect, Mr. Speaker, that this resolution would provide in terms of the legislative position is it would clarify the application of Public Law 26, that's 28, which specifically reads that to enter into a commercial lease or issue a permit or license for the use of its real property and other related facilities, the Port Authority, I added that, shall not exceed 5 years. So this resolution is asking for this body's authorization to be able to provide the position of the legislature on sovereign immunity, who has the authority, and where it is provided, and then on the application of Public Law 26, that's 28, in terms of any restriction provided by this legislative body and any requirement that leases in excess of 5 years shall be considered by this body. Mr. Speaker, I want to read the whereas clause on page 3 from line 13 to 17, and it reads, whereas on December 29, 2016, the court did not find Section 2 of the Guam Public Law 26/28 to be well-defined, explicit, and clearly applicable under the manifest disregard of the law standard for vacating an arbitration award, concluding that the Guam legislature has not provided further clarity as to the policy behind the statute. And that is where this amicus curiae brief, should the authorization be provided by this body, would provide that particular clarity in regards to the position of the legislative body. It also reads, the legislature finds it necessary to register its position regarding Public Law 26/28 to an amicus curiae brief to provide its position and policy behind the statute, and further reads the other provisions, Mr. Speaker. Mr. Speaker, I'd like to close with this, and just very briefly, because I know we've had extensive conversations with this situation, and I look at it as defending the interests of this body on behalf of the people of Guam, defending the position of this body as it applies to sovereign immunity, as well as the application of Public Law 26/28. And the last two clauses read, whereas by applying for and filing an amicus curiae brief before the Superior and Supreme Courts of Guam regarding the specific rulings of Public Law 26/28 and the court's findings that the Guam legislature waived sovereign immunity to an extent greater than is contained in the Government Claims Act, it is the intent of Emina 34 na ley sa Turinguahan that the courts of Guam and all applicable government agencies interpret the relevant statutes in line with Elisa Turinguahan's clear mandates contained therein. And that the 34th Guam Legislature does hereby, on behalf of Elisa Turinguahan and the people of Guam, authorize the Legislative Legal Counsel or other retained counsel to apply for and file an amicus curiae brief before the Superior and Supreme Courts of Guam, affirming the Guam Legislature's position relative to sovereign immunity and the upholding of Guam law. Mr. Speaker, this resolution is asking for that authority to be able to file an amicus curiae brief. And I know that one of the questions that was asked during the course of the public hearing of this resolution was who would assume the cost. And the cost, by virtue of the resolution, the people of Guam would assume that cost out of my office, Mr. Speaker, because I believe very strongly and very firmly that we as an institution, as a co-equal branch of government, have got to relay the position of the Guam legislature as it applies to sovereign immunity, as well as the application of Public Law 26/28. Mr. Speaker, I thank all the employees, the management for their efforts and the ongoing work at the Port Authority of Guam. I know that a number of them who have extreme interest on the eventual action by this body on this resolution have joined us. They're either in the galley or they are in the public hearing room, and I thank them very much for all their ongoing efforts on a daily basis to ensure that the Port Authority of Guam operates effectively and efficiently. Thank you very much, Mr. Speaker.
Thank you, Senator Argan. Are there any senators who wish to be heard on the main motion? On the main motion, any senator wish to be heard? Senator Vice Speaker.
Thank you, Mr. Speaker. I rise in support of this resolution. There are two questions before the court, and one is when the legislature passed a law that says there shall be a maximum of 5 years on a lease, is the court going to recognize that there is a maximum of 5 years on the lease? Are our agencies going to recognize that? Are people contracting with the government going to recognize that? Or are there ways to get around that? The other question that's before the court is whether the legislature waived sovereign immunity. And I believe that the legislature taking a position in this case it's important for us as the third branch of government, as the branch that actually passed this law and is the holder of sovereign immunity, the body that gets to waive sovereign immunity, that makes that decision of whether sovereign immunity will be waived or not. I believe it's important for us to be in front of the court and make that position ourselves. And I want to note for the record that this is a position that the Attorney General has taken in this case, that the Port Authority of Guam has taken, and so it is a position consistent right now with the rest of the government of Guam. And so I think it is important. I have had the honor of representing the legislature in the Guam Supreme Court, and I think it is important that the legislature be there, particularly for these issues, because these issues are our issues. Maybe we have more to lose than the port does. They lose money, but we lose authority over sovereign immunity. We lose authority. I mean, we lose the ability to pass laws to limit leases or not. And for that reason, I believe I support this resolution, and I ask my colleagues to do the same, and I thank the sponsor for this resolution, and thank you, Mr. Speaker.
Thank you, Madam Vice Speaker. Any other Senator Torres? Senator Morrison, was your hand up? No. Senator Torres.
Sidus Masi, Mr. Speaker. I just had a point of inquiry to the sponsor of the resolution, if he would yield to my question. There was a statement made about the funding of legal counsel, and I believe I heard that the funding would come out of the senator's office budget, which I just wanted to clarify. But the sub question also is there sufficient language in the legislation that would also provide for the retention, if not our legislative counsel, for the retention of outside counsel? And is it necessary to put such language in there? The funding source, perhaps an amount, and the mechanism if we were to retain an outside counsel.
Senator Aga, do you yield?
Thank you very much, Senator, for that question. Excellent questions. One, first and foremost, yes, the funding would originate from my office budget. And if it's necessary to retain outside counsel, obviously there are budgetary limitations, but the idea is to ensure that the amicus curiae reflects the position of the legislature on these two issues. We are not necessarily inserting ourselves into the body of the arguments, but presenting the position of the legislature so that, in fact, there's clarity.
Is that response sufficient, Senator Torres?
I just want to ensure that if we need to retain outside counsel, that it's provided for, because I believe that there is a contractual remedy or a contractual process by which we engage. So that's all I'm bringing up is if we're going to go this way, is there meat to it, and can we, or is it necessary to put an amendment to that effect?
Thank you again, Senator. Mr. Speaker, if I can yield to our legal counsel to see if, in fact, there's sufficient language in there to ensure that there's that authorization. The good senator is asking if the language contained in this resolution is sufficient to allow for outside counsel to be acquired. And the way I read it, Um, to me, in simple terms, or other retained counsel, to me that's sufficient language, but I would leave it to our legal counsel if in fact he feels or she feels that that's sufficient language to allow for the attainment of outside legal counsel.
Let's take a short recess and Legislature's back in session. When we broke, I thought we were with Senator Torres asking about an issue, but do we have a resolution?
Thank you very much, Mr. Speaker. And good Senator, if by any chance this verbiage provides for the clarity that you're looking for. Sir, it's on line, I'd like to move for an amendment beginning on line 21 on page 4 of the resolution. At the end of the word law, insert management and cost of said legal services shall be the responsibility of the senatorial office of the primary sponsor of this resolution. And then it goes on to read, and be it further.
Thank you very much for the amendment. Senator Ada on the amendment.
I certainly appreciate the fact that the sponsor of the resolution is volunteering to use his budget funds to be able to pay for the legal fees that may be required. I'm just concerned. I don't know. Do we have any idea of what that cost might be? And then, if we find out that it's just gonna be too much for that senatorial office's budget, we're gonna have to come back here again to do that, as opposed to saying, let the legislature fund this, or either that, or let the legislature fund it, but not knowing how much it's going to cost. I'm afraid that we're going to end up back in here again, because the price tag is too high for his budget to afford. So that's my only concern. But if the sponsor believes that his budget can fund it, then have at it. I just hope that that the amount doesn't impede it.
The amendment has been offered. Senator Aga, do you wish to respond?
Thank you very much, Mr. Speaker. And to the Senator Manila, thank you for expressing that concern. We have budgeted up to $5,000 specifically for this. We did reach out to our legal counsel to get a good estimate as to how much this could conceivably cost, and that appears to be within range in terms of the filing of an amicus curiae brief.
Any other on the main motion? Back to Senator Torres. You had the floor before when you raised that question.
Thank you, Mr. Speaker. I just want to point out that in the legislative section under page 3 under whereas, there was, I believe, one of the underlying reasons the sponsor moved in this direction is because, in quoting here around page 3, line 14, Public Law 26-28, the court did not find to be well-defined, explicit, and clearly applicable under the manifest disregard of the law standard for vacating an arbitration award, concluding that the Guam legislature has not provided further clarity as to the policy behind the statute. And I'm just bringing an issue of concern to me as I read that and as I contemplate the point at which we are in the court proceedings. The timing of this resolution in light of the point at which we are in the court proceedings gives me some pause to reconsider whether in fact this resolution is timely, whether this resolution will actually be well received by the courts. And the reason I bring that up is if in looking at that page 3, what I had just talked about, it appears that we are attempting now, and I would ask the author of the resolution to please, if he will yield to my question. My question to him would be, in passing this resolution, are we as a body in the 34th Guam Legislature ascertaining legislative intent from a prior body that passed Public Law 32 dash, I lost my place. 26-28. Because if that be the case where a latter body is ascertaining the legislative intent of a prior body, it does seem, if anything, very unusual and rather extraordinary. And in considering that type of an action and how the court would actually entertain that type of a amicus curiae brief, I just wonder as to the validity of it at this point in time. Clearly, our stating our position is one thing, but I just want to ask the question of whether the nature of this brief is to ascertain the intent of a body prior to this body, because I believe that this body has no position trying to ascertain what another body meant when they pass legislation. Generally, that is in the legislative intent, and that is what I believe courts generally look to. And if there's no clarity, they have a mechanism by which to ascertain what legislative intent must have been. But if the good author of Resolution 62-34 would so yield, I would greatly appreciate it. Thank you.
Do you yield, Senator? I believe the question is this resolution pretending to ascertain what the intent was of the 26th Guam Legislature when it passed 2628?
Thank you very much,
Talking about what
Mr. Speaker,
could
for
have and should have been the standard.
Thank you for clarifying the position. I think that if there's any individual or any entity that's going to be able to represent this body, branch of government, it would have to originate from here, Mr. Speaker. And I think that in terms of responding to the questions, it's a very appropriate question. Are we entering this entire process towards the, is it even going to have an impact? Mr. Speaker, I am not going to invest the people's money into a question with regards to how sovereign immunity is provided and the application of 26 as 28. I am not going to invest the people's money just frivolously. I believe that there is substance to this. The Port Authority of Guam Board has already authorized an appeal of the case, and you and I know that the filing of an amicus curiae brief in that process would add to that consideration. Now it's up to the courts if they would put added emphasis on it, but I believe that it's a responsibility of this branch of government to be able to render interpretation or the intent of this body as it applies to sovereign immunity as well as the application of Public Law 26 as 28. For me, Mr. Speaker, to stand here and go back to one of my initial presentations, if an arbitration panel can go and negotiate on behalf of their party and the government of Guam and come out with a $15 million judgment or award without the consent of this body, that is really where the concern comes in. Mr. Speaker, do we retain the authority for sovereign immunity, or is it something that already in the law is authorized? If in fact the judicial decision is that sovereign immunity does not apply in this case, then that is where we as members of this body on behalf of the people of Guam need to clarify the law and ensure that we protect the interests of the people, and in this case as it applies to the Port Authority of Guam. So, Mr. Speaker, former Chief Justice, You know and understand the judicial system much better than I could ever explain it. But I believe very strongly that it's got to be this branch of government. Granted, the Attorney General rendered a decision looking at the law and filed an amicus curiae, but it's always beneficial that this body represents itself and ensures that there's clarity as it applies to these two particular positions or situations before the court. Thank you very much. Because there's a change in seat, Madam Speaker.
Thank you very much, Senator Uggan. Does that answer your question, Senator Torres? You have the floor.
Thank you, Madam Speaker. So from what I understand from the answer, and correct me if I'm wrong, we are going to be filing an amicus curiae brief to state and to reemphasize the position of the legislature as a 34th Guam Legislature with regard to sovereign immunity. Correct? We're not filing a brief to ascertain the intent of the 26th Guam Legislature and what they meant to do when they. I just want to be clear because that. If a yes or no answer would be sufficient. Thank you.
Senator Uggan, do you yield to that question?
Thank you very much, Senator, for that question. I think it really boils down to filing as a friend of the court and protecting and representing this body, the legislative branch. I really don't see how else I can explain it other than ensuring the sovereign immunity, which is an organic act authority provided to this body, that is a provision that unless it's waived in specific legislation, remains with this body. And the application of Public Law 26-28, certainly by virtue of the language that the legal amicus curiae brief would be reflective of what the intent of that legislature is. And Madam Senator, you have certainly some very good questions, and I'm just trying to figure out, to understand that if in fact there are two major questions at hand before the courts in a case, providing the courts with a legal position as it applies to sovereign immunity and the application of a law that was passed by this body should certainly clarify the position of this body, whether it's the 26th Guam Legislature or the 34th Guam Legislature. Thank you, Madam Speaker.
Thank you, and I understand your position. Thank you very much to the author.
Thank you. Is on the amendment by Senator Uggan, Speaker Cruz, you are recognized. Did you wish to speak on the amendment?
Just on the amendment, I'm not sure if budgeting $5,000 is sufficient. I know when my office decided to challenge an issue in the district court on the Ladzon case, my office spent just for the retainer $10,000, and were it not for the fact that we were both faced with possible contempt for challenging the court, we probably would have spent more money than that. But I don't know if a budget of $5,000 is sufficient. And I'm not sure whether or not this legislature can afford the cost of taking it from the Superior Court to the Supreme Court, and if need be, any further than that. I know one maritime case for the port cost 12 million in appeals. The equality case last year was $90,000 for that short presentation by the same counsel that is counsel for the port at this time. So I don't know where the money's coming from, but 5,000 just isn't going to cut it.
On the amendment by Senator Uggan, are there any other speakers? Senator San Augustine, you're recognized.
Madam Speaker, with that note of what Speaker Cruz brought up, then I'd like to make an amendment to the amendment that the legislature funds the legal counsel, and if not, if that can't be supported by the body, then I'm willing to contribute to support Senator Uggan's resolution, and we'll see where it goes from there. Because, you know, as reading Public Law 26-28, it talks about a 5-year plan, and they're supposed to have come back to the Guam Legislature. They didn't come back to the Guam Legislature, and for a court to say that you can keep going as many years as you want and not come back to the legislature for approval, just not right.
Thank you, Senator San Augustine. On the Senator Uggan's amendment, are there any other speakers on the amendment? If not, then Senator Uggan, you may close on the amendment.
Thank you, Madam Speaker. I just need to once again clarify that this is filing the position of this branch of government as it applies to those 2 points. And it's not directly inserting the legislative branch in the litigation aspect. It's providing clarity that as it applies to sovereign immunity, the legislature recognizes the authority that lies within this body alone. And unless it's waived, then it remains with this body. And then the application of 26-28, public law. That's it. Rendering our position for clarity purposes, and then the litigation would be up to the Port Authority Guam and the other party. Thank you very much, Madam Speaker.
Point of order, Madam Speaker. Madam Speaker,
State your point of order.
the previous speaker, I just want to find out whether there was, he said he'd like to make an amendment to the amendment. And so I'm just wondering whether that was really, he was proffering an amendment to the amendment. Because if it is such, then we need to deal with that amendment first, the amendment to the amendment.
That's correct, Senator. I didn't take it as a formal amendment. Senator San Augustine, did you wish to offer, were you offering a formal amendment to the amendment?
Madam Speaker, I was offering, yes, an amendment to his amendment that the body funds it. If the
Okay.
body does not accept that, then the next amendment would be to support by providing financial support to that challenging court.
Okay, so we will consider your amendment, which is Senator San Augustine's amendment is to change the words responsibility of the senatorial office of the primary sponsor of this resolution to
Madam Speaker, if we
responsibility of
may,
the legislature?
Madam Speaker, in this particular situation, just to be clear, it would be good to have that amendment in writing as opposed to having it interpreted or paraphrased from the podium. But if there is an amendment to the amendment that's being made
All
by
right,
the
I thought this
senator-
was passed out, Senator. If
I'm
it's
not-
not, then, okay. We will take a
So I-
1-minute recess and pass this amendment out.
Thank you.
Okay, we're back in session. Senator San Augustine, you're recognized.
Madam Speaker, is, after speaking with the sponsor of the resolution, I'm going to withdraw my amendment, and then we're going to discuss this later. Thank you.
Thank you, Senator San Augustine. So Senator Frank Uggan's amendment has been passed out. It's, has everyone received a copy? So, is there any other discussion on the amendment? On the Senator Frank Uggan's amendment? If not, then Senator Uggan, you may close. All right, he's waiving the closing. So on the amendment, all in favor, please raise your hand. All in favor of Senator Frank Uggan's amendment, please raise your hand. Oh, I'm sorry. Is there any objection to this amendment? If no objection, so ordered. On the bill, are there any other speakers on the bills? Speaker Cruz, you are recognized.
Madam Speaker, I wasn't going to speak on this resolution, but I was a little concerned by some of the comments that were being made. I'm at loss as to what sovereign immunity or whose sovereign immunity is being questioned. About 40 years ago, I believe, this legislature created the Port Authority of Guam. And in creating the Port Authority of Guam, gave the Port Authority of Guam the authority to sue and be sued. I believe this legislature has waived the sovereign immunity that would or could have been claimed by the port had it remained a government agency. It's one of the few places where they've been given the authority to sue and be sued, as opposed to some of the executive branch agencies. So I guess maybe that's my first question. What sovereign immunity are we talking about? If it's the issue of whether or not this legislature can and should have spoken up sooner about the fact that in 26-28 we had a 5-year requirement and 5-year maximum lease provision, we probably should have spoken up a lot sooner. I know for a fact, because I was at a couple of board meetings when a current member of our legislature was the executive manager at the time, and the issue was raised about the lease. And had they wanted the legislature to submit something, we should have submitted it a good 8 or 10 years ago. But the reason why I really had to stand up today is because I'm a little concerned about an insinuation about an arbitration panel. I'd like to remind this body that the court did not, I want to repeat that, the court did not, by its own rules, authorize arbitration as a means of resolving cases. This legislature, years before I came, and I came here 12 years ago, years before I came, had the progressive thought of suggesting that arbitration be a form of resolution of civil cases. Admittedly, it's only been recent that the Supreme Court has issued an opinion on how it's going to view arbitration awards. And in their opinion, they decided to take the strictest reading and announced that absent fraud, an arbitration award is final, is not reviewable. I believe the Superior Court reaffirmed that in its initial, after it was questioned. It's now trying to address it again. But that it has been resolved. I know arbitration is this legislature passed arbitration so long ago that I can remember as a Superior Court judge handling what we're talking about now, challenging the findings and award of an arbitration panel. And in my ruling, I found a very tangential relationship or conflict by one of the panel members and tried to set the arbitration aside. It went up to the District Court Appellate Division. It was that far back. And it went up to Ninth Circuit, and I got slapped down royally. Unless there is evidence that the three members of the panel were colluding and involved in some fraudulent activity, the Supreme Court of Guam has said its finding is final. The comments made from this floor that shocked that three individuals who didn't come up for confirmation could be making this decision in an amount more than the Government Claims Act. This legislature was the one that passed the arbitration statute. And recommended to the courts that arbitration be used. And it was the Supreme Court of Guam that, in looking at the case, said the contract says if there is a dispute, it'll be resolved by arbitration panel. And in fact, it said every issue, if there is an issue, is to be resolved by the arbitration panel. I'm not happy with the way that the arbitration panel came down. I may believe in my heart of hearts that it was wrong in its calculations. But a previous legislature adopted the idea of arbitration. And it's been going on for over 20 years, because I know it was 20 years ago that I handled that case, because Senator Frank Santos was still alive. So we're now going to, unless of course there is some talk or thought in this legislature to repeal the arbitration statute, good luck. Because if we think we have a backlog at the judiciary right now, were it not for the fact that a previous legislature had the progressive foresight to encourage resolution by arbitration, we would need to appoint 30 judges. Every single day, there are cases, in the plural, that are being arbitrated as we speak. One of the former judges of the district court had an arbitration office in Sinahanya. 10 years ago. The AAA arbitration from San Francisco and JAMA have been coming out here for decades, helping us resolve civil cases. And if this body is now saying that people that weren't confirmed and faced a confirmation hearing can't make decisions, I'm a little concerned with that kind of talk. I just wanted to place those issues on the floor.
Thank you very much, Speaker Cruz. On the bill, on the main motion, are there any other speakers? If no other speakers, Senator Esteves, you're recognized.
Thank you, Madam Speaker. This is a mess. There's no other way to say it. I think when you look at the history as outlined in this resolution and then also on my individual research, it's a mess, and it's come full circle. We look back to the legislature that passed the law, 26-28. We look at the executive arm improperly issuing a bad contract, issuing out a straw deal, straw purchase. And then now to the courts that I do believe are infringing on the sovereign immunity of the legislature. When we look, and I'd like to refer to line 13 through 17 on page 3, whereas on December 29th, the court did not find Section 2 of Guam Public Law 26-28 to be well-defined, explicit, and clearly applicable. It's simple, Madam Speaker, as we look through different lenses. The court's opinion is one thing, and it's really not our problem whether or not they understand it or determine whether or not it's clear. Further to state that the Guam Legislature has not provided further clarity. So when we look at the process and the execution from the court side, is they're just moving along forward, muddling, blind, unaware of the intent. And it's been brought up. Do we as a body have the ability to determine the intent of previous legislatures? I want to say, in simple terms, we do. It's the same intent that every single legislature has within the government of Guam, is the fiduciary responsibility of the people's money and to pass laws for the people of Guam. That intent has not changed, and that it doesn't matter. Anybody who's elected, that is our responsibility, the fiduciary responsibility. So what it comes down to in this whole mess involving all three branches of government is everybody looking at it with a different lens. But what I believe it comes down to is, for me, maybe I'm a simple man and I don't have a law degree, but when I look at 26-28, within either the lens of a simple man or the lens of a senator, is it's not to exceed 5 years. The lease was not to exceed 5 years without approval from the legislature. I don't know how simple we can make it. I don't know. I can find a fifth grader who could understand that terminology. I tell them don't go there, they don't go there. But again, I'm not a judge. All I have is the responsibility as a duly elected official to have the fiduciary responsibility of the people's money. And when we look at how this all came about, and I say it went full circle because I think there were faults on all three branches of government in this, is that it comes down to a straw deal. The contract and lease was executed without the proper authority to execute that. And I support this resolution, and I support my colleague in his statement that in supporting this is saying that we are giving up our authority as a body. Because when we say, well, even though the law stated this, that they have to come back to us, and somebody ignored the law, then we further allow another branch to ignore the law. And we let everybody walk over this body of 15 duly elected representatives of the people who have the fiduciary responsibility of the people's money. And so maybe I'm oversimplifying it, but I think we do need to take a simple approach to this. I think the law was very clear. And with that, again, would just like to highlight, I am in full support of this resolution. I am full support of this body exercising and taking serious our fiduciary responsibility and maintaining our sovereign immunity and maintaining our right as a body to say whether or not we wanted to apply here or we wanted to apply there. I think that should apply to this body. It is our right as a branch of government. It is right for this body to do it. And again, we can't change things in the past, but we do need to stand up for what the right thing is. Thank you.
Thank you, Senator Estevez. On the main motion, are there any other speakers? Senator Sinicolas, you're recognized.
Thank you, Madam Speaker. I too rise in support of this resolution, in large part because of what it represents in terms of implications, not just with respect to this one case that is proven to be very convoluted, but with respect to other pieces of legislation that could find its way into the same convolution. When I just read the resolution itself, it already contains elements here that make me kind of step back and wonder how did it even get this far. For example, on page 2, lines 1 and 2, it reads, whereas Port Council in 2011 advised the port that the lease agreement was expired and terminated as a matter of law and was void. How do you determine that a lease is expired if that lease was invalid to begin with? I think the problem initiated when we said something was expired that actually was not proper to begin with. On page 1, lines 14 and 15, it reads, whereas the lease agreement with the port exceeded the 5-year maximum the legislature set in public law. Now, the whole idea of arbitration and the ruling of the panel, the amount, all of that makes for a very sensational story. But the original question is, should it even have gone to arbitration? If arbitration was an original component of the lease, then yes, you should go to arbitration if the lease is valid. If the lease from the beginning is invalid, then arbitration has no bearing. So as you follow the story, and it was very well articulated here in the resolution, the original ruling of the Superior Court was that arbitration had no basis because the lease in and of itself at the onset was invalid. The Supreme Court took a look at it and said, the motion that was filed was with respect to arbitration, you need to rule on arbitration. And then that's when this whole thing turned into a big mess, because if arbitration was a component of a lease that was invalid, then why are we compelling them to continue through the process? And the reason why this is an important question to ask, Madam Speaker, is because, for example, if we pass a law that says that we're authorizing $100 million in borrowing to go and build Simon Sanchez. And if in authorizing that $100 million in borrowing, we require that certain procurement processes are followed. And we require the project meet certain standards. And we require, more importantly, that the interest rate of the borrowing is, let's say, 5%. And we pass that law. And then everything gets initiated, and the powers that be go and authorize a financing for 10%. And they sign a contract that compels arbitration if any of the parties involved are dissatisfied. Now, if the law originally limited the borrowing at 5%, and they went and they signed a contract that compelled a borrowing at 10% and arbitration, do we then go and arbitrate whether or not there should be some kind of a settlement? Absolutely not. The law only authorized 5%. You went and did 10. You already went beyond what the law authorized. That's exactly the problem that we have here in this case. What the law originally authorized was a 5-year lease, not a 5-year with option to renew to 45. So the original lease in and of itself was invalid, the same way that a bond authorization that exceeds the original mandated interest rate would be invalid, regardless of whether or not the parties agreed to arbitrate any differences. So it's very important that we clarify this question, because otherwise, if we don't, the precedence may very well be that regardless of what we mandate in public law, so long as the parties have an arbitration clause, they can violate the stipulations of the mandate. At least they can violate it within the scope of whatever the arbitration finally determines. And that basically allows any panel of 3 or however many the arbitration panel will be in that particular circumstance, but allows a panel to, at any time, circumvent Guam law. It allows for contracts to be illegally entered into and for a panel to so decide whether or not Guam law should be applicable. And the bigger question that needs to be answered is, do the laws of this land rule, or do the contracts that are in violation of those laws rule? Very clearly, the law rules. And if we need to get that very elementary assumption validated by the court through an action like this, then so be it. Because the risk of not doing so is the risk of us allowing every future law that we pass to get circumvented by a contract and arbitration panel that will completely disregard the limitations that we set in our mandates. So I rise in full support of this resolution, and I really hope our courts look at this very carefully. Thank you, Madam Speaker.
Thank you, Senator San Nicolas. On the main motion to put the bill in third reading, are there any other speakers? Senator Espadon, you are recognized.
Thank you, Madam Speaker. I guess I need to understand what the author of this resolution, what his understanding might be of what the issue is before the court at this juncture. There have been arguments already made that this whole process has gone through several trials and court proceedings. And to my understanding right now, the issue is really centered on the arbitration award itself. And so I just want to clarify exactly what the author's understanding of the issue, of what the issue is before the court, before we file an amicus brief. And I would have to at least couch that in terms as I'm not really sure that the issue before the court right now, as one of our colleagues stated, is whether or not whether or not the 5-year rule on any government leases was circumvented, or whether or not there was a sovereign immunity issue. My understanding is the challenge right now is how do you overturn the arbitration award? And I could be mistaken, but I need to hear from the author what his view is on this in proposing this resolution.
Senator Uggan, do you yield to that question? He's asking that you repeat the question.
The question is bottom line, what would be the author's understanding of the real issue before the court at this time? Because my understanding is the issue is the amount and the awarding of the arbitration award and nothing else. But I could be mistaken.
Senator Uggan?
Thank you very much, Madam Speaker. Thank you, Senator, for that question. First and foremost, I think the previous speakers and other speakers have really alluded to the issue. The first is the application of Public Law 26 as 28. Anything in excess of 5 years needs the concurrence and the approval of the legislature, a valid lease. So in this particular case, it went to an arbitration. The issue here is outside of the Government Claims Act, the way it's been, the award was provided exceeds the allowable amounts under the Government Claims Act. So the question is, in this case, was sovereign immunity waived by virtue of the arbitration process?
And that is the case before the court right now, or is it?
I'm not even going to speak about the litigation. I know that Senator, there are two issues that this legislative body, by virtue of the resolution, should provide clarification to the courts of Guam, and that is on sovereign immunity and where the authority lies. The second component is the application of Public Law 26-28, whether a lease agreement that spanned a time frame, I believe, of 45 years, anything in excess of 5 years needed the approval of the legislative body. So in this particular case, we're providing, should this resolution pass, we would provide the position of the legislative body as it applies to sovereign immunity and Public Law 26-28. With regards to the litigation, I'm not going to comment on the actual litigation itself and where it is in the process.
And I appreciate that, but again, I'm still a little, perhaps, disturbed, right? Because even one of our colleagues who was with the court did mention those arguments probably should have been proffered at a much earlier time. If at this point in time we're trying to attack the award that the arbitration panel awarded, right, that comes under a whole different set of arguments that can be made. And really, to overturn an arbitration award, really, and I believe reading in the paper in previous months, right, that even the Attorney General said it's a very narrow opening, right, in which you can attack the arbitration award. And really it has more to do with issues like collusion or fraud or other things that may have happened in the awarding process. Whether or not these arguments of sovereign immunity and the lease issue, the 5-year lease issue, will be or can even be entertained in this proceeding to try to overturn the arbitration award is in question. at least in my mind, because that argument has come and gone. Right? Regardless of how we feel, I think all of us here, in fact, even the Attorney General back in the day when she found out about the ward, he even tried to intervene at that point. But it was too late. And so I'm just wondering if by going down this road, not that I oppose having a say, but I have to at least question whether we go through this process and state our position on that, but it has real no effect on what really is the resolution that we're trying to seek. And that resolution that we're trying to seek is the overturning of the arbitration award. And so I have to at least question that. That being said, Madam Speaker, I thank you for the opportunity.
Thank you, Senator Espaldon. On the main motion to send the bill to third reading, are there any other speakers? Senator Agan, you may close.
Madam Speaker, there were a few, first of all, I want to thank our colleagues for their comments and their questions and certainly their consideration of this resolution. I understand that it's been relatively contentious, and the media has certainly covered it quite well. When I look at this and I look at the question of sovereign immunity and the application of Public Law 26/28, we need the courts to render a decision based on, should this resolution pass and the authorization provided, based on sovereign immunity and 26/28. If the ultimate decision of the courts is that the arbitration award remains, then that is where we as members of this body will be obligated to visit and to revisit the arbitration, the sovereign immunity provision, and the application of Public Law 26/28. If by virtue of providing clarity of the position of the legislative body on those 2 points, the courts renders a decision otherwise, then certainly it would provide us with some legal guidance through the judicial system in terms of what step we need to take next. To me, it's about protecting the interests of the people of Guam, albeit whether it's through the Port Authority of Guam because they are presently in litigation. I see it as a responsibility of this body to be able to provide its position on those 2 issues that is part and parcel of the question before the courts. Upon the conclusion of their action on any appeals, then we will know what steps to take, if any, moving forward. But we need this question resolved, because anytime that we can have a third group render a decision or an award in excess of what's authorized beyond the Government Claims Act, then I believe that this legislature certainly needs to revisit some of these provisions in the best interest of the people of Guam. So thank you very much, and I ask our colleagues for your consideration. Thank you.
Thank you, Senator Agan. On the motion to send resolution 62-34 to the voting file, any objection? Hearing none. We only have one more matter before us. Senator Munya, bill number 1.
Thank you, Mr. Speaker. And I think where we left off, I want to thank one of my colleagues for bringing up the focal point on the high-risk term. Thank you so much for directing our attention to that. Before I offer and propose my amendment, I do want to talk a little bit about high risk and just to allow my colleagues to maybe direct some of their attention, if they will, to the Guam Comprehensive Cancer Control Coalition under the Department of Public Health and Social Services. They have a website that develops a 5-year plan. And in this 5-year plan, they gather facts and figures and they put this all together. Currently, the 5-year plan is from 2008 to 2012. They are currently working on a more recent 2013 to 2017 right now. But in their website, if you go to this, you will see very specific facts about age and gender and ethnic groups. And there you may get a little bit better understanding about what is considered high risk. At this point, though, generally speaking, cancer really doesn't discriminate to anybody, no matter what your age and your gender and your ethnic background is. So what I offer, Mr. Speaker, is if they can and they'd like to, maybe not specifically for this bill, but maybe to go to that website and take a look at it and just see how cancer is affecting Guam on the island today. And so what I'd like to do upon careful review from my colleagues' focus on high risk is offer an amendment, propose an amendment, because I determined that the bill contained language that was relevant to PSA tests. And since PSA tests are no longer covered screening tests, it was removed from the original version of the bill. The language related to the PSA test was not removed. That was an oversight on my part, which is the antigen, the prostate-specific antigen test. That was an oversight on my part. So the amendment that I'm now proposing cleans it up and contains only what is necessary, and that is to maintain covered prostate cancer screening. So if I will, there was a proposed amendment passed out to all of my colleagues, if I can just direct their attention to that, and I will offer this amendment.
Has everybody received a copy of the amendment? Any senator wish to be heard on the amendment proposed by Senator Muñoz? Senator Nicholas.
Thank you, Mr. Speaker. I appreciate the amendment as proffered. My intent in my initial questioning of this particular section was more so with respect to the ethnic limitation as opposed to the age issue. And ideally, I would prefer that we just make it be a blanket 35 years of age that gets covered, as opposed to making it be 40 years of age without any kind of ethnic consideration. So I guess to pose to the author, would she be opposed to us having the age, instead of being 40 years of age as she's proposing in her amendment, making it be 35 years of age?
Thank you, Mr. Speaker. I did do some research on that as well. As far as the DRE, digital rectal exam, it doesn't yield very much physical and visible findings at age 35. It does, though, in fact, be covered by 40. So the information that I have is DRE screening is recommended at least for men age 50, with high-risk individuals at age 45 and very high-risk individuals at age 40, which is the reason why the insurance companies now cap it off at 40.
Senator Nicholas, is that sufficient?
Okay, so just to clarify, because the 35-year-old here was because it was for very high risk, but based on clarification from the author, DREs are effective for very high risk at 40 years old. So I appreciate the clarification.
So on the amendment, any senator wish to be heard on the Muñoz amendment? Senator Lee?
Thank you, Mr. Speaker. I'd also just like maybe additional further clarification. In the original language of the bill, it stated at least 35 years of age, but less than 40. And in this subsection, at least 35 years of age, less than 40, and is in a high-risk group. And I believe the high risk, meaning a person who is of Asian, Native, Hawaiian, Pacific Islander descent, that covers everyone in this room. We'd all be considered high risk. So, yeah, I agree with Senator Nicholas. and if maybe we could get further clarification on why it couldn't just be prostate cancer screening test for a person who is 35 years of age, at least 35 years of age, if the author would yield to that question.
Senator Munya?
Thank you, Mr. Speaker. Let me just go ahead and I'll just clarify a little bit more. The amendment removes the provision for high-risk screening for persons aged 35 to 39. The reason for the removal is because we eliminated the PSA exam as an option for screening. If you may recall, the USPSTF gave the PSA a D rating, and that rating means insurance companies would not cover the exam. Because without adequate counseling, it may cause a patient to seek potential or surgical procedures and tests, dangerous surgical procedures and tests. So we determined that we'll keep it standard from the USPSTF guidelines at age 40.
Is that satisfactory? Thank you. And on the main motion? No, I think we're still on the amendment, aren't we? Anything further on the amendment? Any objection to the amendment? On the main motion? On the main motion, Senator Munya, you're recognized to close. Senator Lee, you want to speak on the main motion?
Thank you, Mr. Speaker. I rise to reiterate my support for Bill 1-34. I believe that securing preventative screening through local statute is critical to providing prostate and cervical cancer care. We all know that Guam suffers disproportionately when it comes to cancer, and I look forward to continuing to working with this body to expand critical coverage through this bill and similar policies, including preventative measures like the HPV vaccine coverage. I also want to rise to honor the legacy of Miss Henrietta Lacks, who died of cervical cancer in Baltimore, Maryland in the 1950s, and is just now gaining rightful acknowledgement for her contributions to cancer treatment, polio vaccines, AIDS treatment, and many others. Every single human being who benefits from modern medical advancement has benefited from HeLa cells, of which Ms. Henrietta Lacks is named. So I should take note, they were taken from Ms. Lacks without her consent. So for Ms. Lacks, for my grandparents, my family members, and all of our loved ones who face cancer, and all of those who work to find a cure, I ask this body to join me in support of Bill 1-34. Sijus Masi.
Thank you very much, Senator Lee. Any other senator on the main motion? If not, Senator Munya, you're again invited to close.
Thank you, Mr. Speaker. I feel like we're coming full circle with this bill. First of all, I want to thank all of my colleagues for their input and their support. Definitely for my first bill was a very learning and enlightening experience, and I also want to thank all of the people who helped me develop this bill, legal counsel and all of the stakeholders, including the insurance companies that gave me guidance in developing this bill. I don't think it's any secret in my journey up to this point that cancer was my main focus on, to get here today. And it will always be, because this bill actually means a lot more to me because my mom was diagnosed with cervical cancer 4 years ago. So it really does mean a lot to me that everybody's giving their input to make this the best bill possible, because really, when you look at it, the best cure against cancer is screenings and tests. And what I'm afraid of, if the repeal of ACA, if the Affordable Care Act is repealed, that we're going to take a step backwards, and really that's not what we're trying to do. We're trying to take a step forward and reduce those numbers of deaths with cancer. Right now, with the study from the Guam Cancer Facts and Figures, every 2 to 3 days someone dies of cancer. And what we're trying to do is we're trying to reduce that. And the way we can reduce that is by offering screenings and tests, making it available and more easy for them to get it so that we can reduce the number of deaths for our family and friends. And so this really means a whole lot to me, and the insurance companies are in support of continuing this coverage, and I hope that the body here and my colleagues do also continue this support in this fight against cancer. Thank you, Mr. Speaker.
Thank you very much. On the motion to send Bill 1 to the voting file, there being no objection, Mr. Assistant Majority Leader, you're recognized.
Mr. Speaker, notwithstanding the House rules, I move to go back to motions.
Any objection to moving back to motions? Hearing none.
Mr. Speaker, I move to place from the Committee on Education, Finance, and Taxation the following nominations. Gerald W. Philish to serve as a member of the University of Guam Board of Regents with a recommendation to confirm. Mark Benevente C. Menjolo to serve as a parent of student enrolled within GDOE representative of the Guam Education Board with a recommendation to confirm. Edward B. Palacios to serve as a member of the Cockpit License Board with a recommendation to confirm on the legislative concurrence.
On the motion to place, hearing no objection, Senator Narcastine, you're recognized.
Mr. Speaker, I move to place the same on the voting file.
Any objections to placing these nominations on the voting file? Hearing none. We've exhausted the calendar, and it's now almost, it's 4:20. I'd like to recess until 3 tomorrow afternoon to allow legal counsel in the clerk's office to engross all the bills, and we'll come back tomorrow afternoon at 3. There's been a request to make it later. It's a short voting. It's 8 bills and 4 resolutions. If we meet at 4 o'clock and give them all the time. All right, 4 o'clock we'll recess, and we'll be voting at 4 o'clock tomorrow afternoon.